Are we recording? Yeah. Rule 38 of the Employment Tribunal Rules of Procedure provides that the tribunal may, on its own initiative or on the application of a party, strike out all or part of a claim, response or reply on any of the following grounds. A. That it is scandalous or vexatious or has no reasonable prospect of success, that the manner in which the proceedings have been conducted by or on behalf of the claimant or the respondent, as the case may be, has been scandalous, unreasonable, or vexatious. For non-compliance with any of these rules or with an order of the tribunal. D. That it has not been actively pursued. E. That the tribunal considers that it is no longer possible to have a fair hearing in respect of the claim, response or reply, or the part to be struck out. Sub 23, subparagraph B above is the appropriate section. There is no question but that the manner in which the proceedings have been conducted by Miss Ashwell have been scandalous, unreasonable, or vexatious. At a very basic level, she has failed to attend 2 hearings, despite a good many letters from her over the last few months that she has not disputed the fact that there is a warrant or taken issue with the reason given by the respondent as to why it was issued. Accordingly, the test in Rule 38 is more than met. Judge Fowl relies on Rule 38(1)b of the Employment Tribunal Rules of Procedure 2013, asserting that the manner in which the proceedings have been conducted by Miss Ashwell has been scandalous, unreasonable, or vexatious. Due to my alleged failure to attend 2 hearings and correspondence regarding a police warrant, this characterisation is procedurally and factually inaccurate. 1. Non-attendance misrepresented. I submitted multiple emails to the tribunal in advance of the hearings requesting remote participation, consistent with precedent where other claimants, including those living abroad, were granted remote access. The tribunal denied me access while the respondent attended remotely by video. Denying my participation while accommodating the respondent constitutes a clear procedural irregularity and demonstrates bias, contrary to Rule 3 of the Employment Tribunal Rules of Procedure 2013, which obliges tribunals to act fairly, impartially, and in accordance with the overriding objective. 2. Conflation with unrelated police matters. The tribunal relies on alleged police warrants and criminal proceedings to justify striking out my claim. These matters are entirely external to the civil claims of constructive dismissal, sex discrimination and bullying under the Employment Rights Act 1996 and the Equality Act 2010. Using alleged criminal matters as a reason to preclude participation exceeds the tribunal's statutory jurisdiction, as confirmed in R on the application of Edwards v. Environment Agency 2006, EWHC 1698 admin, which limits tribunals to adjudicating within their statutory remit. 3. Fabrication and retaliation. The alleged criminal cases were fabricated by the respondent and their associates, selectively relying on minimal evidence, while over 5,000, now over 6,000, pieces of exculpatory evidence proving harassment, collusion and intimidation were ignored by West Midlands Police. My arrests were retaliatory and designed to intimidate me, not reflective of any genuine risk posed to the respondent. The respondent's framing of me as a threat to witnesses is deliberately misleading and amounts to an attempt to influence the tribunal unlawfully. Procedural unfairness. By striking out my claim on the basis of alleged non-attendance and purportedly scandalous conduct, the tribunal fails to consider my legitimate explanations and requests for remote participation, as required by Rule 47(2). This misapplication of Rule 38(1)b prejudices my right to a fair hearing under Article 6 of the European Convention on Human Rights. Defamatory characterisation. Labelling my actions as scandalous, unreasonable, or vexatious misrepresents my conduct and minimises the seriousness of my claims, including retaliatory arrests, harassment, stalking, collusion, and sexual assault. In reality, it is the respondent's conduct that is vexatious and retaliatory, not my pursuit of justice. Conclusion. The Tribunal's reliance on Rule 38(1)b is factually inaccurate, procedurally unfair, and demonstrates bias in favour of the respondent. My actions, attempting to participate remotely, raising serious employment and criminal matters, and complying with tribunal instructions where possible, do not meet the threshold for strikeout. Any decision based on these grounds is unsafe and unsustainable, providing clear grounds for appeal and the recusal of Judge Fowle.